Good evening. Thank you for joining our estate planning webinar. My name is Paul Lindsay and I'm one of the estate planners here at MacMillan Estate Planning. So, the plan is to spend around 40 minutes today covering the essential components of a comprehensive estate plan to give you a flavour of both our business and some of the solutions that we can look to implement for you and your families. Many of the families that we've been speaking with recently are becoming rather worried about the future. Perhaps understandably, they're anxious about COVID-19 and the risk it poses to them and their loved ones, but they could also be worried about a lot of issues beyond that, both globally and closer to home. Thankfully, many of those families tell us that we make them feel a little better because we give them a sense of peace of mind and empowerment. Not because we've solved all of the world's issues, far from it, but they feel better because we arm them with the strategies that they can use to protect themselves from a wealth preservation and legacy planning point of view. We give them the ability to control a portion of their lives, irrespective of what the future brings. As part of our process, we spend a considerable amount of time educating, if you will, the families about options available to them that will help to protect their estate from a number of risks. Family issues, market volatility and tax. I'm going to look at some of those at a broad level with you this evening. But if you have any other questions surrounding the design of your bespoke estate plan, I would encourage you to take advantage of a complimentary consultation, be that with me or with one of my colleagues. During the initial session, we will explore the issues and gather information that will allow us to provide you with a number of bespoke recommendations, focusing on your primary concerns and needs. Indeed, there will be a link provided at the end of the presentation so that you can request a consultation yourselves. Not only will you be able to come and meet with me or one of my colleagues, but you will also be entered into a prize draw to win a fully paid 12-month sponsorship of an orphaned baby elephant. That's via the Sheldrick Wildlife Trust, which is a charity that our CEO Sherry holds particularly dear. So, before we get into some of the key elements of a comprehensive estate plan, I wanted to share a little bit about our business. MacMillan Estate Planning was founded almost 25 years ago by our president and CEO Sherry MacMillan. It was founded as a result of an experience that Sherry had whilst working at one of the big banks, and she found that the bank was placing its own interests ahead of those of their clients. This didn't sit well with Sherry, and so soon after MacMillan Estate Planning was born. We service an extensive geographical area, currently operating through Western Canada, the US and in the United Kingdom. MacMillan Estate Planning has provided our clients with virtual estate planning services for well over 10 years, and we've got all of the people and the processes and the tech in place to meet almost every planning need without you actually having to step into one of our physical offices. As I turn to the next slide, you will see a list of professional designations. We have professionals accredited and affiliated with all of those designations in-house, which allows us to provide truly comprehensive estate planning services. At the end of the day, our lives have become very complex. Families are often spread out across the world. We have assets in different provinces and countries. Whilst this creates opportunity, in some instances it also creates a restriction. That's why it's important that we've got a group of professionals that can come together and look at things for you from a multidisciplinary perspective, so we can make sure that all aspects of your plan can be properly addressed. Now, taking this idea of a multidisciplinary team just a little bit further, the next slide shows the two approaches to estate planning: the compliance or traditional approach as against the strategic approach. The traditional approach is the one where you will find yourself meeting with one professional at a time. One day it could be your lawyer, the next accountant, by the end of the week your investment advisor. Now, you've then got the task of reconciling all of that advice, some of it could be conflicting, and pulling it all together into some kind of estate plan. The strategic approach that we use involves all of those services being made available at one location. We're a bit like a wealth architect, and we look to join the dots between all of the disciplines and then present all of the expertise and ideas to you. And I can show you how that approach is beneficial. And let's look at the common practice of putting a child's name on the title of main residence or a family cottage. Usually it's with the aim of simplifying the probate process or something of that nature. Now, you go and see a lawyer and they will often comply with the client's request to do this transaction, and it's a fairly simple one. The problem is that the lawyer is sometimes only looking at this from a legal perspective. So if we think about that property being your main residence, we've now, by doing the transfer, got a deemed disposition of the residence. You can get the appropriate main residence exemption, but your child has taken that property at a zero cost base. So when they sell it in the future, it's almost a certainty, if you will, that they will incur tax. So by doing that simple transfer, instead of having an asset that could be growing tax-free for you and then passed to your children without tax, we've inadvertently created a taxable event by transferring it during lifetime. Stay with that example. It isn't just the tax that could be an issue. Now think about, you want to sell your home. Well, in that scenario, you're going to need the permission of your children to deal with the sale because they now own. What if your child suddenly is facing a divorce? You could find that the ex-spouse is now claiming that your home is matrimonial property and they want a share of it. Equally, the relationship since the transfer could have broken down with your child for some reason, which will also, of course, cause complication. So it's really important to be able to join the dots and effectively reconcile the advice that you get from all of your advisors, and having them under the same roof really does help with that. Your full service team at MacMillan is comprised of not only the professionals, of course, but more importantly you and your family, because the expectations of your family and other beneficiaries maybe is something that we've got to pay real attention to when we build the estate plan. We like to call it the Christmas dinner question, in fact. The idea is we ask all of the families that we work with, if your family knew what your estate plan looked like, would they still come home for Christmas? At the end of the day, it's not unreasonable for your children, usually, to have some expectation of inheriting from you. You've got to be mindful of these expectations and have made a reasoned decision concerning how you're going to manage them. So why create an estate plan? Well, of course, this is the big question. Now, before we go into some of the elements of a comprehensive plan and some of those strategies I talked about earlier, I'm just going to quickly cover off the reasons why many families tell us they've created a plan. In Canada, at the moment, around 50% of people don't have a will. I suspect that the number of people who haven't done any comprehensive planning is infinitely less. Creating an estate plan is about taking control, making sure your objectives and your goals for the future can be met. We feel that once you've got an estate worth more than $1 million, you've got to get more than the traditional basic will planning. Even in these uncertain social and economic times, how can you empower yourselves through your planning? Well, the answer lies in just thinking about ways to minimise tax, preserve wealth, protect the bloodline, and ensure family harmony. Tax is something you can't get away from completely, but there are ways that we can be smart about it. And here at MacMillan, we help you to minimise tax. This could include capital gains planning, which will involve discussions about your principal residence, as well as the other exemptions and mitigation opportunities available. In terms of how we might preserve wealth, well, we want to protect the value of your investments so that we ensure that their value is guaranteed and safeguarded against losses during a market downturn. This, of course, is key to maintaining living standards through retirement. And we have to be very cognizant of the fact that we're now in an ageing population. Retirement could be longer than your working life. The idea of bloodline protection, well, that relates to the means by which we can protect your estate for your bloodline, ensuring that it's not lost to third-party forces like a divorce, bankruptcy, litigation, or even your spouse or partner forming a new relationship after your passing. The concept then we come back to of family harmony, well, that wraps everything together. When we talk about family harmony, we're making sure that when you die, we reduce the risk of any litigation or infighting in the family. Because for those of you who've ever been involved in that sort of thing, you'll know that it's not a pleasant time and it can involve great stress and huge legal costs. Now that we've covered a little bit about our firm, the importance of a comprehensive approach to estate planning and the reasons to actually undertake the exercise, I want to look at the most important component of the plan, and that's you, your family and your significance. Your significance is what is most important to you today. Protecting it is a moving target through life. What is significant now could change and evolve as your life unfolds. Your younger years, it could be that your family is your significance. Then it's your career or business, and in retirement, simply enjoying the spoils of your labour by travelling, doing charitable work, or just being able to spend more time with your loved ones. Your significance matters, and you deserve the right to safeguard it for the benefit of you and for your family. So now we're going to get into the part of our presentation when we're going to look at the different components of a comprehensive plan and also touch on some of the more relevant strategies available to most families. A strong room historically was a fortified room in the castles or stately homes of noble families during the Middle Ages. These families would store things like jewellery, money, land titles, other legal documents or items of importance, so they'd be protected from attack by any external forces. We see your estate plan in the same way, but we're using the tools available to us as practitioners to give you and your family your very own strong room as a mechanism for protecting the estate. And we build the strong room to safeguard your significance, which is at the very centre of the planning. The different facets of the plan surround and protect your significance, and they're all working in harmony together. Your life plan is always the driving force, and so we start by implementing this particular plan to make sure that your significance is protected, preserved, and so that your estate can be enjoyed during your lifetime, because we've got to be mindful that you've built this estate, and so it's not unreasonable for your goals and needs to be of paramount importance. We then look at your legacy plan. Now, if we've done the life planning properly, the legacy plan just flows from it naturally. Your legal plans and your tax plans are really just the technical tools that we use to enforce life and legacy planning. They support and inform objectives, they don't define them. But all of these things working together is really important. Now, a legal plan, typically that's a will, a power of attorney, a personal or health directive, and some trust planning. Now, the very phrase COVID-19 has only within the last sort of year become a part of our general vocabulary, but it has made many of our clients and families consider their mortality in a little bit more detail. I'm sure many of you know that a will operates to the extent that it decides how your estate will be divided and administered after you pass. You get to decide who's going to act as executor, amount and subject of any legacies, and then how the remaining assets pass. Quick aside, it is worth reminding you that if you don't have a will, then the government will decide how your estate is administered. And this not only removes your personal choice, but it also could give rise to a distribution that doesn't meet with your wishes, quite frankly. As I've talked about already, when your estate becomes in excess of $1 million, you've outgrown a simple will. You've got to be looking at something to give you that additional protection. Now, with the uncertainty, as I say, that remains as a result of the global pandemic, you must have that clarity and peace of mind wherever you can. And a power of attorney and a personal directive can certainly be of assistance here. A power of attorney lets you appoint an attorney to manage your property and finances if you lose capacity during your lifetime. We hope this document never sees the light of day and that you will always be managing your estate. But it's a really important document within the estate plan. If you lose capacity without a power of attorney, it's likely going to be your family that are going to have to make a lengthy and costly application to court to get the right authority to manage the estate. Personal directive then, sometimes known as healthcare directive, representation agreement, or as part of a living will, is a document that allows you to appoint an agent to make decisions about your health and well-being if you lose capacity. Decisions here customarily include end-of-life care, life-sustaining treatment, things like that. But it's real invaluable guidance to family members at a time when scenario is probably quite unexpected, and so it's a really significant component of the legal planning portion. I've always told my clients to think of powers of attorney, personal directives, as being like insurance policies, in that we don't want to pay the premiums, but if we ever need to make a claim against the policy, we're glad that we have them. The same is true with these documents. They give great reassurance for families at what is almost always an emotional and stressful time when they're being used. That then takes us to our next topic, which is trust planning, and possibly a little bit less well known. Now, a trust really is a legal relationship where trustees hold assets to manage on behalf of a beneficiary or beneficiaries. Historically, trusts span back to the 1200s and the times of the Crusades in Europe. Since then, they've been used as a tool to control the passing of assets to beneficiaries and as a way to sort of safeguard those assets generally. They can be created during lifetime when they're known as inter vivos trusts, or come into being when you pass, when they're known as testamentary trusts. Now, to show you a little bit about how they work and how they're beneficial, I'm going to tell you a story about a family we've been dealing with recently who have substantial net worth, and they want to limit their children's access to the wealth. They're not just worried about maybe the dreaded daughter-in-law or son-in-law from hell, but also the impact that that wealth has on their children's outlook on life, the development of their work ethic, and a fear that they'll just become trust fund babies. So we've recommended what is known as an incentive trust. And the incentive is that if the children get out of bed each day, they go to school, they find jobs, the trust is there to support them. But it doesn't actually enable them to just rely on the fund. We've actually proposed that the trust will let the children take an income from the trust equivalent to their own personal income. Now, as a brief aside, we can include non-financial factors as well here, but as you'll see, herein lies the incentive for the children to succeed. They do nothing, they earn nothing, they get nothing. Trusts are really useful as well when we have parents of children who maybe have health conditions which mean they'd struggle to manage any inheritance. So using a trust means that child can still benefit, but there are controls in place to dictate how that is done, and we structure it in such a way that they won't lose their entitlement to any government benefit programs that they may be entitled to. Finally, we have to think about a scenario where a parent has a child who has problems with alcohol or substances, so if they had a direct benefit from the estate, it could do them more harm than good. Quite frankly, it could have catastrophic circumstances. So using the trust, we make sure that said child can be provided for, and equally, if they turn their lives around, we can then look to use the flexibility within the trust to distribute and provide for that child in a slightly different way. We're also using them commonly, or trusts commonly I should say, in the blended family, where you've got spouses who've been married before, they've got children from those previous relationships. So using trust there, a spouse can discharge their legal, moral obligations towards the new spouse, but ultimately ensure that the estate passes to their children, if that's what they want, when both spouses have passed. A number of our wealthier clients, aged 65 years or over, are creating a particular type of trust called a joint spousal or alter ego trust, which here we term the Secure 65. Now, this trust protects underlying assets from creditor claims and also provides complete privacy for a family in that third parties are unable to find out about the nature and extent of their assets. Now, if the assets aren't held in a trust and go through probate, any third parties can make inquiries of the court and obtain documentation which will show an itemised account of your estate and a copy of your will. This trust also provides for enhanced administrative efficiency when you die, because the assets held by the trust aren't subject to probate. So in many provinces there's a real opportunity to save significant fees, and at the same time it's a lot harder to challenge a trust compared to challenging an estate. And my final point here is that unlike other lifetime trusts, there's no tax payable when assets are first rolled in. So the next component of the strong room approach is life planning. A life plan is about giving definition to what you want from your life going forward. Put simply, it's a bucket list in terms of all the things you want to achieve and how you're going to make them a reality. And good planning should focus on your life, which is why we make it the main facet of the strong room. People today are living longer. At the moment here in Canada, there are over 48,000 people aged over 100. That number's growing. It's also the first time ever that there'll be more people over the age of 65 than under. And if you get to be 100 or more, you've got to make sure that market volatility, tax, health and care are properly accounted for, so you're protected both now and for the decades ahead. And here we're going to look at some sort of ideas about investment protection, private and principal guarantees and business succession. Your investments should ultimately supply your family with a concrete source of income for retirement. Losses as a result of tax, market fluctuation or other externals like divorce, bankruptcy or a lawsuit can be avoided if the correct precautions are taken. When it comes to business succession, surprisingly 70% of all family-owned businesses in Canada don't properly go to the next generation. Now, to ensure your company's future and avoid unnecessary complication, you really must have an effective business exit plan. Then finally, we've got principal guarantees, and this means that you get the peace of mind knowing that the value of your principal investment is guaranteed, regardless of what happens during your retirement years in financial markets. You'll see here actually a guaranteed investment in action in this real life example. Noting at year one, our client invests $100,000. The value grows from year 1 to year 5 to $140,000, and throughout, our client gets to activate resets or lock in the gains represented by the circles. Year 3, $110,000, year 4 at $130,000, and finally locked in at year 5 at $140,000. Then we say that at year 6 the pandemic began, and this decreased the value of the investment from $140,000 back down to $100,000. The shaded area, spanning year 5 to 10, shows the decrease in the market value. But irrespective, our client's principal is protected at $140,000 due to the principal guarantee. Now, if we assume that the client dies in year 10, the darker circle, the client's estate won't receive the market value at the time, which is $120,000. The estate will actually get the highest locked-in amount of $140,000. Now, assuming in year 11, when the asset has transitioned to the beneficiary, markets improve, investment grows, the new owner can continue to lock in the higher amounts and protect the principal and give them their own peace of mind for their own retirement. Now, looking at the tax plan, the third component. Your tax plan is an important technical tool, and it's used to protect your life and legacy plans. It doesn't control the planning, but it supports your goals and objectives. Every year, countless people pay far too much tax to CRA. Now, tax is an unavoidable reality, even in a well-designed estate, but using the right tools, we can reduce or defer this sum. And a proper tax plan has to account for both domestic and international issues, because families are unaware that internationally held assets like property or investments, perhaps in the US, are then liable to both US and Canadian tax. And if we don't structure these within a larger tax scheme, there's going to be some real loss to the value. Foreign assets, by their very nature, also create multiple estates from a legal point of view. By owning property in the US, you then have an American and a Canadian estate. And when you die, these estates are going to have to be settled. And this adds to the time and cost required to do that. Tax minimisation could be as simple as us talking to you about an RSP withering strategy so that we can structure the sort of sources of retirement income and how that will ultimately result in a tax saving. But something else we really want to talk about here is this idea of an estate freeze. An estate freeze is a really advanced asset protection and tax strategy where a business owner looks to defer tax on a portion of their business's value by freezing its present value and then allowing others, usually family members, to share in the growth whilst deferring the tax liability to them at the same time. And this is done by reorganising an existing share structure and commonly in conjunction with the use of a family trust. From a planning perspective, using an estate freeze and then quantifying the tax that's going to occur on the passing of the business owner really can have numerous benefits. If we know what that tax liability looks like when the business owner dies, we can put a plan into place to make sure that those taxes are paid without disrupting or even destroying the business. And there's also an opportunity to eliminate or reduce that liability anyway over the business owner's lifetime, reducing the capital gains tax even further. Now finally, this strategy can also enhance the business succession plan because it gives your successors the opportunity to get some skin in the game so they can see that any future growth or value is coming to them, which strengthens their ongoing participation in the business, all whilst the initial owner retains control. The fourth aspect of the strong room is your legacy plan. This plan should transfer your vision, wisdom, belief systems to the next generation, ensuring that your legacy will then resonate and endure. Now, we look at your legacy plan this way. If you think you've got 2 children, well, maybe you've got 3. The third's name is Canada Revenue Agency. If there are assets outside of Canada, maybe we are adding perhaps the IRS to the list as well. So what do you do if you've got these 2 insatiable children who are always wanting more from you? Well, you could send them away for adoption, but how can you do that? Well, it's by replacing them with a charity of your choice, because up to 75% of your net annual income can be claimed as charitable donations. In the year of death, up to 100% of your income. So it's a substantial opportunity to save tax while supporting a charity of choice or beginning a legacy of your own. If the donation is large enough to eliminate all tax in the year of death, you can carry back 1 year, which creates additional tax savings. The legacy plan also must account for estate administration and probate. Usually the administration of an estate takes around 12 to 18 months to conclude, but it depends on your particular estate or if there's litigation. We have seen the administration take many years to resolve, but don't forget, whilst being administered, assets are frozen. And so executors cannot take steps to react to market volatility during this period, for example. But there are strategies we can use. Could be as easy as having designations on life insurance policies and registered accounts. Indeed, trusts can also be of great assistance in bypassing the probate process. We have talked about a lot of concepts this evening at a very high level. Many of the concepts and ideas presented may not be suitable in your unique circumstances. However, that is why we offer potential clients a complimentary consultation so you can sit down with a qualified planner and ask questions related to your own planning and get answers that are specific to you and your family. I will now be sharing, as promised, the link to the form so you can request a complimentary consultation with one of our planners. Also, just a gentle reminder that by filling out the form, you get the chance to win a subscription, sponsorship, if you will, of an orphan baby elephant via wildlife charity, the David Sheldrick Wildlife Trust. It's a great gift. You'll get lots of updates, pictures and videos of your very own elephant as it grows up in the reserve without actually having to own it in your home. My kids have sponsored a few recently, and it's a really great gift, both for children and grandchildren, I suppose. With that, I will end the presentation this evening. Thank you again for taking the time to join us, and I hope to see some of you again soon.